Thank you, Mr. President. 39. I don't know if, let me read. Say subject to any other provisions of this act. All claims, judgment, debt enforcement. I think it should be judgment, debt enforcement, I believe. In which case that comma should be removed. So it should be judgment, debt enforcement.
That comma should not be there. Chairman, have you listened to the SP? Is that correct? Judgment, debt enforcement. So the comma should be deleted. The comma. Only the comma. Those in favor that clause 39 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 40 on page 92. Clause 40 on page 92. Those in favor that clause 40 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 41 on page 95. 41 on page 95. Those in favor that clause 41 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 42 on page 97. Those in favor that clause 42 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 43 on page 98. Those in favor that clause 43 stands part of the bill say aye. Those against say nay. The ayes have it. A new 39. No, that's deleted. Okay, there's a new 43 on page 99. The new 43 is on page 99. Those in favor that clause 43 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 44 is on page 101. Those in favor that clause 44 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 45 on page 104. Those in favor that clause 45 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 46 on page 105. Those in favor that clause 46 stands part of the bill say aye. Sorry? 45. Those, sorry? Clause 46. Clause 46 on page 105. Those in favor that clause 46 stands part of the bill say aye. Those against say nay. The ayes have it. Yes, Senator Balanala.
Mr. President, sorry to take you back. I am not as fast as you can go. But section 40, clause 43, sir, appears to be in contravention of the Constitution of the Federal Republic of Nigeria, sir. It's not. No. It's a new 43. Yes.
Page 99.
At page 99. The new 43. Yes, sir. It says, except with the written consent of the governor, no bank shall to be registered or incorporated with a tribal or ethnic name or any name which includes the word central, federal, federation, national, Nigeria, reserve, state, Christian, Islamic, Muslim, Quranic, or biblical. This will clearly violate the provision of the Constitution, sir, because in the Constitution, sir, any person can come together for the purpose of fostering an economic agenda. And if, for example, it's the decision of the Christian Association of Nigeria to build a bank for the benefit of their people, that is expected to be allowed, because first, the Constitution gave them right to practice their religion, unhindered. So I think we have to be a bit careful about this because it's unconstitutional, sir. That's my fear.
Senator Ibukule Amosun.
Thank you, Mr. President. Ibukule Amosun, I represent Ogun Central. Distinguished colleagues, yes, without prejudice to what Senator Nala said, drawing our attention to this, I think there is no way we can write everything out like this. Yes, it is written. But since that proviso is there, that except with the recent consent of the governor, it is just to make sure that people do not abuse this. That is what I think. Because they are not saying they cannot, but they are saying that they probably need the consent of the governor so that decorum will be maintained. You know the way we are. You can, yes, I agree with you. You can have Christian whatever bank. You can have even Ijo whatever bank. But some may be such that the governor will want to advise. I don't think there's anything wrong with this because they are not saying they cannot. So
to be a bit cautious, sir. Oh, okay.
Well, Mr. President, my highly respected and distinguished colleagues, on this particular issue, I think I really concur with I do understand the position of Senator Balana Allah, but I think the word except, so I do respect the position of Balana Allah, but I do concur with the position of Senator Ibukule Amosun. Given the nature of this country, the frivolous usage of some of these very loaded terms, if they are not checked, could bring us into a lot of unnecessary conflicts. So I think this clause was inserted so that the central bank governor can be able to advise and to be able to actually notify the kind of intendment of those who are promoting this business. So that if there is no problem of taking those names, he will just say, okay. But if he senses that there are certain kinds of issues, behind the usage of those terms, he could now say that you have to expulge, that particular term if you are to be registered. So I think it's to err on the side of caution. And therefore, I really support the position of Senator Amosun without really dismissing the constitutional issues that have been raised by Senator Balana Allah.
It is one thing for an act to be constitutional or not constitutional. It is another thing to subject the fundamental rights of citizens to a discretionary exercise of power by an individual. This is the caution that I'm trying to draw. It is even more serious, Mr. President, when we consider the unique nature of the Federal Republic of Nigeria. If tomorrow, God forbid, they say distinguished Senator Ojikalu is the central bank governor, and then I apply, sir. I apply to register a bank in the name of, let's say, Islamic Bank or something. And in his opinion, it does not work. And then he says, I'm not going to grant the consent. Meanings will be read to it. So that's why nowhere will a fundamental right, nowhere will a fundamental right of a citizen be subjected to the discretionary exercise of an individual. That's the only thing. And I still maintain my position that this provision is unnecessary. The consent to register a bank is entirely that of the central bank governor. There is no need to put this as a cobweb for him to hang him to the exercise of power when we know ab initio it is unconstitutional. I will seriously and respectfully advise that the provision itself is even unnecessary, that let it be deleted. Thank you, sir.
I think I will agree to a large extent with submission by Senator Bikule Amosu. Nobody is denied that right. And all that I think the clause intends to achieve is to ensure that there is no frivolities or recklessness in just writing whatever somebody wants. Your argument on the face of it is okay. But if we just allow it like that, probably it will be a subject of litigation unnecessarily, because there will be no provision for anybody to checkmate that possible recklessness that could result. So I would advise that we leave it as it is. And because Parliament will be here, even if we will not be here, if there is any abuse, then the Parliament can amend it. Senator Alero.
Thank you, Mr. President. Mr. Chairman, distinguished colleagues. Mr. President, I think it is dangerous to leave it as it is now, because we cannot make law that go against the Constitution. Any law that goes against the Constitution, to the extent of inconsistency, is null and void. That is the position of our Constitution. And there are so many organizations now that are interested in setting up non-interest banking. And if you subject the approval of non-interest banking to a particular individual, Mr. Chairman, it is dangerous. What the Constitution has given you, nobody can take it away from you. So I'm of the opinion that we should delete this section completely.
Thank you, Mr. President. Very distinguished colleague. Mr. President, I follow the discussion with rapt attention. But if you look at it from the two angles, one, the first one is afraid that why should we give the sole power to a single individual? And the second one is saying it's just as a guide to checkmate. In balancing the two, I'm of the opinion that there is a board of Central Bank of Nigeria where we have people with diverse opinion, diverse mind, that whenever any such thing is put before them, there will be need for them to read through. So we can simply say, except with the written approval of the board of Central Bank, then that will guide. Single individual will have been taken care of. The caution we are trying to draw will have been taken care of. I so submit.
Thank you, Mr. Chairman, distinguished colleagues. Aliu Sabi Abdullahi. I think he has tried to solve the problem so that perhaps the fear is taken care of. But the key issue, I think, from the debate is whether this issue is impinging on some people's right within the consent of the Constitution. To my mind, it is not, because it is not saying absolutely that you cannot. It is rather saying they need to guide. And this becomes necessary if you are following the trend on social media and other media of what is happening, where people will just use this name innocently and just get unsuspecting public to bring in money through the back door and the central bank has no control over those people. And I think it's very important that we put that at the back of our mind, because many people are losing their money from people who just come out using that name, just what this clause is trying to cure. So I I support what Solomon Adeola is saying, because that will also take care of fear people are expressing about who does it.
Well, distinguished colleagues, we have already voted on this, unless you want me to put it to vote again. So, are we taking the amendment of Senator Solomon Adeola? Sorry? No need. No, that is an opinion. So, I will put it to vote again. As someone, no. There is an amendment that is seconded. Those in favor of clause 43 as amended, say aye. Those against, say nay. The ayes have it. Secretariat. Senator Solomon Adeola, you write that amendment properly, please. Just like you have said it. So we go to clause 46 on page 105. Yes, Senator Johnson.
Mr. Chairman, sir, I'm just being curious. On page 104, on page 104, 45, the extant law is talking about prohibition of strike or pandemic. The extant law, the one that is recommended by the committee is completely different. Strike is being left out. It's only pandemic or what is included here, strike is left out. I don't know whether somewhere in the bill, the issue of a legitimate strike is part of the reasons why a bank will not be held liable. 45. The strike is not there anymore. I don't know where the strike is somewhere.
Mr. Chairman, where did you hide it?
Four. Chairman, the extant law is the principal. This is talking of during a strike or pandemic, but your recommendation does not include strike.
Which page is that?
Page 104.
What is the recommendation? Comments? Which one? What did you want to conclude? There should be strike here. Don't put strike here. Where? Here.
You see?
Yeah, I'm looking at the.
I think we just put strike here. Don't put strike here.
Where is it? From here. 45.
Page 104.
No, I have my.
Oh, yours is different.
No, they can include the strike.
They can include the strike.
Mr. President, I think we agree that we can include the strike in the provision. We can include the strike in the Mr. President, I think I've gone through the sections, and I think I agree with my colleague. We can include the strike there. We can amend it.
We are taking back the strike. So how does it now read? Because we have to have a final position on this. So it means we have to include no. Clause 45, 1. will now be no bank shall incur any liability of any of its customers by reason only of failure on the part of the bank to open for business during a strike. That should be one. No, the heading can be, yes, just you add the strike. Okay. So Secretariat, take note. I think it's something we have agreed on. They should include the strike. Just like the principal act, closure of a bank during a strike or pandemic. Isn't it? Okay. We are past that. So clause 46, those in favor that clause 46 stands part of the bill, say aye. Those against, say nay, the ayes have it. Yeah. Clause 47. Clause 47 on page 106. Amendment 47.
Mr. Chairman, distinguished colleagues, clause 47, page 107, 47 2D. This section is talking about people who can hold positions in a bank. It's a small amendment I want to make. 2D says if a convicted person, if convicted of an offense, individual of dishonesty, of fraud, 107D is convicted of any offense.
Convicted of what?
Involving dishonesty or fraud. I want to add sexual offenses. If you are convicted of sexual offenses, you can't hold a position. The section is talking about those who can hold position in the bank. Yeah. Talking about those who can hold this. It doesn't matter. It's the same thing. The section is talking about disqualification and exclusion of critical individuals for managing a bank. Both men and women.
Okay. No, let's finish with one first. You say 47 2D. 2D is convicted of any offense involving dishonesty, fraud, or sexual offenses. Okay. No, just hold on, please, Senator Susan.
Mr. President, why I support the amendment, there is an issue that comes with it, Mr. President. And the issue is that this particular provision is lifted from what is in the Constitution. And in the Constitution, you don't have that of sexual offense. And so, why the amendment here is good, if somebody takes this matter to court and the Constitution comes in as a superior statute, it might be a problem. But the amendment is good if we can take it. But this is lifted from the Constitution. And so that is the only thing that is a snag on this. No, you see.
This offenses register that has been opened, does it mean that register is of no use?
Distinguished colleagues, I really sympathize with the position our colleague Senator Betty Apiafi has taken. But my understanding of this dishonesty or fraud, these are things that are not required in an environment of trust in terms of banking. So I'm not sure if sexual offense can go in line with this. But can we find Senator Said Al-Ghali?
Mr. Chairman, if she reads Section D, she should go ahead to read Section E. Is guilty of serious misconduct. Is guilty of serious misconduct in relation to his duties. What she is saying is a misconduct, so Section E covers that.
No, Mr. Chairman. Mr. Chairman.
It's a misconduct.
You see, Your Excellency, I can understand what she was trying to say, but we have to understand that sexual harassment or rape or whatever it is, that is a criminal act. But here we are talking of dishonesty, because when you are talking of banking, you are talking of trust. Trust. That should be the main thrust. But sexual offense cannot be part of this, really. Please, let us be serious.
Thank you very much, Mr. Chairman. The argument so far has already exposed the difficulty that we will get into in accommodating this amendment. Now, if you look at E, Mr. President, E says is guilty of serious misconduct in relation to his duties. In relation to his duties. So there is no relationship between the duties of a banker and sexual offense. So this is not wide enough to cover that misconduct. Fluid as misconduct is in its determination, I'm of the opinion that the position of Senator Susuan stands valid, sir. We might find somewhere to accommodate it, maybe, but here it appears almost impracticable to relate his duties as a banker in relation to sexual offenses. It's very difficult, sir. Thank you, Mr. Chairman. Thank you, Mr. Chairman. I'm inclined to go with. I am inclined to go with Senator Nala to the extent that the proposal must be germane. It must be germane to what we are considering. And we are considering the qualification of somebody who will serve as a director or a managing director, what have you, in a bank. So to the extent that we will consider that proposal, that conviction must necessarily derive from his employment. If he's convicted for a sexual offense, it has to arise from the work environment. It must be germane. It must be germane to the position he's seeking in the bank at that particular time. So it's not just enough that he's been convicted for a sexual offense. There must be probably somewhere else where we can bring that, but for sure, not under this provision. Thank you, Mr. Chairman.
Just to buttress the point, I am inclined to support supporting the position taken by my learned friend. My only addition is that this is law that we are enacting, and we will leave it for people to interpret. And during interpretation, we don't want people to have problems in interpreting the law, because there is the etiusdem generis rule, where some other things that are not added, you can apply those things. But where you want to apply something and the thing does not fall in line with what is provided for, then it becomes a problem for those who will have the responsibility of interpreting the law. So, Mr. Chairman, the position taken, if for any reason you want to include that one, it's not this one. Maybe in another, in another provision, not this one. Thank you, Mr. Chairman.
Distinguished colleagues, let's vote on this, please. I think we have listened to the two sides of the argument. So I will put the question. Because this is not supposed to be second reading. We are considering a report. So those in favor of clause 47, that it stands part of the bill as it is, say aye. Those against it, say nay. The ayes have it. Clause 48. Clause 48. 48 is on page 109. Those in favor that clause 48 stands part of the bill, say aye. Those against, say nay. The ayes have it. Clause 49. Clause 49. Those in favor that clause 49 stands part of the bill, say aye. Those against, say nay. The ayes have it. Clause 50. Those in favor that clause 50 stands part of the bill, say aye. Those against, say nay. The ayes have it. Clause 51 on page 102. Clause 51. Those in favor that clause 51 stands part of the bill, say aye. Those against, say nay. The ayes have it. Clause 52 on page 113. Those in favor that clause 52 stands part of the bill, say aye. Those against, say nay. The ayes have it. Clause 53. Those in favor that clause 53 stands part of the bill, say aye. Those against, say nay. The ayes have it. Clause 54 on page 114. Those in favor that clause 54 stands part of the bill, say aye. Those against, say nay. The ayes have it. 55 on page 116. Those in favor that clause 55 stands part of the bill, say aye. Those against, say nay. The ayes have it. Clause 56. Clause 56. Those in favor that clause 56 stands part of the bill, say aye. Those against, say nay. The ayes have it. Clause 57 on page 118. Clause 57. Yeah, 57, Senator Johnson.
Because that particular provision is very sensitive, considering the type of society we live in, I just want us to be very careful, and perhaps for the chairman of the committee to explain, for us to understand what that provision is all about, because of the type of society we live in. Thank you, Mr. Chairman.
Can you give us a clarification on clause 57 on page 118? Prohibition of unlicensed financial institutions.
Clause 157. Is it 58 or 57? 58. Okay, I have my own. Page what? Page 118. I have two major issues. Calm down.
Clause 57. Those in favor that clause 57 stands part of the bill say aye. Those against say nay. The ayes have it. 58 on page 120. Clause 58. Those in favor that clause 58 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 59 on page 122. 59. Those in favor that clause 59 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 60 on page 123. Clause 60. Those in favor that clause 60 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 61. Those in favor that clause 61 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 62. Those in favor that clause 62 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 63 on page 127. Clause 63. Those in favor that clause 63 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 64. Clause 64. Those in favor that clause 64 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 65 on page 132. 65. Those in favor that clause 65 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 66. Those in favor that clause 66 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 67. Those in favor that clause 67 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 68 on page 136. Clause 68 on page 136. Those in favor that clause 68 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 69, standard for payment. Those in favor that clause 69 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 70 on page 137. Those in favor that clause 70 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 71. Those in favor that clause 71 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 72. Unclaimed funds. 72. Those in favor that clause 72 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 73. Clause 73 on page 142. Clause 73. Those in favor that clause 73 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 74. Those in favor that clause 74 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 75. Those in favor that clause 75 stands part of the bill say aye. Those against say nay. The ayes have it. Yes, DSP.
To bring you back to 140. 140, that's section 72.3. 72.3. The way an account which is transferred under subsection 2 of this section is subject to a service charge the charge may continue to be levied up to the date on which the account was transferred to the register of dormant accounts. I take that back. I was thinking that even when dormant, they were still going to be charging. I take that back. Thank you.
We'll go to clause 76. Those in favor that clause 76 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 77, levy on banks, page 148. Those in favor that clause 77 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 78. Clause 78. Those in favor that clause 78 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 79 on page 150. Those in favor that clause 79 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 80. Those in favor that clause 80 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 81. 81. Deputy Chief Whip.
Thank you, Mr. Chairman, distinguished colleagues. I leave Sabi of the line. Clause 81, continuing at page 151, that is subsection A, where it said two representatives of the bank to be nominated by the governor, one of whom shall be a deputy governor, who shall be, B is missing, appointed as the chairman of the board of trustees. B is missing.
Those in favor that clause 81 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 82. Those in favor that clause 82 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 83 on page 152. Those in favor that clause 83 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 84. 84. Deputy Minority Leader.
Secretariat of the Board of Trustees, that there is hereby established for the Board of Trustees a secretariat which shall be situated. D is missing.
It's legal. Well, it can be situated.
No, there shall be no B if it is a legal language. If it is situated, there shall be no BE there. It is either we remove BE or we add D.
We remove the BE.
Yes, we remove BE.
Those involves clause 84. As amended. Shall situate. We delete the B, the BE. Shall situate. Okay, it's a legal document. Those in favor of clause 84 as amended, that clause 84 stands part of the bill, say aye. Those against say nay, the ayes have it. Clause 85. Those in favor that clause 85 remains part of the bill, say aye. Those against say nay, the ayes have it. Clause 86. Those in favor that clause 86 stands part of the bill, say aye. Those against say nay, the ayes have it. Clause 87. Those in favor that clause 87 remains part of the bill, say aye. Those against say nay, the ayes have it. Clause 88 on page 156. Dissolution of Resolution Fund. Those in favor that clause 88 stands part of the bill, say aye. Those against say nay, the ayes have it. Clause 89. Those in favor that clause 89 stands part of the bill, say aye. Those against say nay, the ayes have it. Clause 90 on page 157. Those in favor that clause 90 stands part of the bill, say aye. Those against any, the ayes have it. Clause 91, annual report. Those in favor that clause 91 stands part of the bill say aye. Those against any, the ayes have it. Clause 92. Those in favor that clause 92 stands part of the bill say aye. Those against any, the ayes have it. Clause 93. Those in favor that clause 93 stands part of the bill say aye. Those against any, the ayes have it. Clause 94 on page 160. Those in favor that clause 94 stands part of the bill say aye. Those against any, the ayes have it. Clause 95. Clause 95. Those in favor that clause 95 stands part of the bill say aye. Those against any, the ayes have it. Clause 96. Those in favor that clause 96 stands part of the bill say aye. Those against any, the ayes have it. Clause 97 on page 163. Those in favor that clause 97 stands part of the bill say aye. Those against any, the ayes have it. Clause 90. Clause 97. Those in favor that clause 97 stands part of the bill say aye. Those against any, ayes have it. Clause 98. Those in favor that clause 98 stands part of the bill say aye. Those against any, the ayes have it. Clause 99. Those in favor that clause 99 stands part of the bill say aye. Those against any, the ayes have it. Clause 100, power to grant exemptions. Page 166. Those in favor that clause 100 remains part of the bill say aye. Those against any, the ayes have it. Clause 101. Those in favor that clause 101 remains part of the bill say aye. Those against any, the ayes have it. Clause 102. Those in favor that clause 102 remains part of the bill say aye. Those against any, the ayes have it. Clause 103. 103, DSP.
To be amended thus. 103.1. The tribunal shall consist of not less than 10 persons to be appointed as full-time members by the President of the Federal Republic of Nigeria. Period. Period. We should delete on the recommendation of the governor. And if I must provide a rationale, we have had so many situations where... Oh, okay. Thank you.
Let us explain the situation, sir. You need to explain the reason so that the members will be clear of the reasons why.
Thank you, Mr. Chairman. The reason I'm making this amendment is because for some time now, we have had ministers who have been part of the identical powers in most of our extant laws, who have not turned themselves into de facto presidents, to the extent that even when a president makes an appointment, they will come and say that they were not the ones who made the recommendation to the president, and therefore that nomination, should not go forward. We are not in any way saying that Mr. President should not consult. He has the right to consult, but we should not write into the law that it is the minister or the governors in this case that must make the recommendation. But Mr. President is free